You are welcome to yet another episode of HN What's Your Say? The #1 listening show, where we discuss real issues with real people like you. We are still featuring R. Kelly. Real name Robert Sylvester Kelly. Also known as the R&B King. Today we take a deeper look into one of the most misunderstood aspects of criminal law. The Racketeer Influenced and Corrupt Organizations Act, which is better known as RICO. Attorney Jennifer Bonjean raised an intriguing interpretation of this law during R. Kelly's New York appeal hearing. Her statement was so informative and strong that it sparked debates among legal experts, true crime enthusiasts and ordinary case observers alike. She argued that a RICO organization isn't just a group with a criminal in it but a coordinated and structured enterprise whose purpose revolves around criminal activity. To quote her exact words, the experienced appellate attorney did state that simply speaking, a RICO enterprise is a criminal organization to define it broadly, but is not an organization simply with a criminal.
But you can't just have an organization that is not associated with any crime. Simply speaking, a RICO enterprise is a criminal organization. You can define it broadly, but is not an organization simply with a criminal.
This was checkmate for the state attorney who was present to defend the usual lies of government. Now let's unpack this concept in detail and explore what it means for cases like R. Kelly's. First, let's understand what RICO is and why it's significant. Enacted in 1970, the RICO Act was originally designed to combat organized crime. We are talking mob bosses, drug cartels and other entities that operated as well-oiled criminal machines. The key feature of RICO is its focus on repeated patterns of criminal behavior rather than isolated acts by self-guided individuals. Under this law, prosecutors don't need to prove that a specific individual committed a specific crime. Instead, they must show that a person was part of an organization that fundamentally engaged in a pattern of racketeering activity. The power of RICO lies in its ability to dismantle entire criminal enterprises and not single individuals. It targets the structure, the hierarchy and the collective intent of the organization, not one man's decisions. But as RICO prosecutions expanded beyond traditional organized crime, the law's broad language began to raise questions. Can a loosely affiliated group of individuals busy doing legitimate work and performing only legal tasks qualify as a RICO enterprise? Is it enough to have a criminal within an organization, or does the organization itself need to be inherently criminal? A RICO organization is not just an organization with a criminal in it but a criminal organization rooted in crime as the common and primary purpose. This brings us to Jennifer Bonjean's argument. During R. Kelly's appeal hearing, Bonjean emphasized the distinction between a group with a criminal in it and a group that functions as a criminal organization. Her interpretation challenges the trend of using RICO to prosecute individuals who are suspected to have engaged in criminal activity but were not part of a coordinated criminal enterprise. This has become a trend especially when handling high-profile cases with celebrity defendants. For as long as the defendant was part of any form of business entity, be it a company or, like we saw with R. Kelly, a music management team, the government has been clinging on to this to present this team or company as a criminal enterprise even if the defendant acted alone. This is so wrong and cannot be allowed to continue. Thankfully, Attorney Jennifer Bonjean has addressed this, and a win by R. Kelly in New York could shape a new and more meaningful interpretation of RICO. Let's break this down. Imagine a music label where one member engages in illegal activities, such as bribery or exploitation. Is that music label automatically a RICO enterprise? Bonjean argues that it shouldn't be. For a RICO charge to stick, the organization must have a purpose rooted in criminal activity. It's not enough for a criminal act to occur by one person within the organization. The organization itself must operate as a vehicle for committing crimes. Historically, RICO was used against groups like the Mafia, where the entire structure existed to commit crimes like extortion, money laundering and murders. But in recent years, RICO has been applied more broadly and carelessly. We've seen it used against sports organizations, corporations and even high-profile individuals like R. Kelly. This expansion of scope raises critical questions. Are we diluting the original intent of the law? And are we at risk of confusing criminal behavior by an organization member with the existence of a criminal organization? To understand this further, let's examine the criteria for a RICO enterprise. According to the law, a RICO organization must have either a formal or informal structure, a common criminal purpose and continuity. Bonjean's argument hinges on the second and third points. Having a structure alone is not enough. Common purpose and pattern of racketeering are the central requirements for the organization to qualify. She contends that these elements require the organization's purpose to be intrinsically criminal, not merely incidental to the actions of one member. So how do prosecutors demonstrate a common purpose? In traditional organized crime cases, this is relatively straightforward. The mafia's common purpose might be to control illicit businesses while a drug cartel's purpose is to manufacture and distribute narcotics. But in cases like R. Kelly's, the alleged enterprise often consists of employees, associates and affiliates whose primary purpose is not inherently criminal. For example, a music manager's role is to book gigs and not to commit crimes. During the trial, prosecutors argued that R. Kelly's inner circle formed a criminal enterprise to facilitate his alleged abuse. But Bonjean pushed back, questioning whether the group's primary purpose was truly criminal or whether some individuals committed crimes independently. This distinction is critical. If the group's common purpose wasn't criminal, can it truly be considered a RICO enterprise? No. Legal experts have in fact expressed concerns about the expanding use of RICO. Some argue that it's being weaponized to secure convictions in cases where traditional charges might not suffice. While this can be effective in holding powerful individuals accountable, it also risks criminalizing ordinary organizations for the actions of a single bad actor. Should we reserve this powerful law for clear-cut cases of organized crime? Or is there room to adapt it to modern cases in a different way? And where do we draw the line between a group with criminal elements and a bona fide criminal enterprise? As we've seen, the distinction between a criminal organization and an organization with a criminal in it is more than just a legal technicality. These are two different things altogether. What do you think? Should RICO be applied more narrowly, or is its current scope justified? Let us know in the comments below. Don't forget to stay tuned to HN Newsroom for more in-depth legal analysis. If you want to be featured in our video releases, send us your clips by emailing them to hnnewsroom242@gmail.com or use Google Drive for larger files. Be sure to include your name and any details you'd like us to know. We can't wait to showcase your contributions. That is all we had for you today on HN What's Your Say. To keep updated whenever we post a new video, subscribe to this channel now. Also remember to hit the bell icon and enable notifications. And feel free to share your opinions with us in the comment section below, and let us know if you would like us to publish your views in our next release. We value all our subscribers' opinions.